Here we are with one of the most important constitutional separation of powers issues, and people will not let me speak.
This is my First Amendment right.
What I'm going to do now is allow...
There's cameras here. The marshals just saw you. The marshals just saw you. You're in trouble. You're in trouble. You just assaulted me. That man just assaulted me. He stuck a flagpole in between my legs.
Yeah.
Don't touch me. Don't touch me. There you go. You're in trouble now. They're calling television services. I was just assaulted.
Look, if you got a sign, hold it over there.
Liar.
I can hold it anywhere I want. This is public property, sir.
Assault. I want to press charges.
Let the man talk.
Charges.
Are you interested in hearing him?
Man, go ahead, Peter. Go ahead and talk.
You're on
I don't agree with some of your shit, but go ahead and talk, man. Go ahead and talk.
No, I did it. No, I did it.
Go ahead and talk, man. Go ahead.
Sad day for America, not because they were guilty verdicts, because I can't come out and have an honest, decent conversation with the people of America. People of America, I want you to understand that this is the problem we have right here. This kind of divide in our country between the woke Marxist left and everybody else here. And this is nuts. So what I want to try to do here is have an interesting discussion about what just happened. That's what you all want to know. You want to know what just happened. So I'm going to give Mr. Raleigh first crack at this. And there's some issues that each of my attorneys here, Mr. Irving, Mr. Brand, where did these guys go? They're back there. And let's just do it. Now, look, I appreciate if you guys can work through there's no problem with the print media. You get it, right? I apologize to the pool camera, but maybe you can kind of, that's what editors are for. So, Mr. Raleigh, have at it, my friend.
Thank you. Listen, on behalf of Dr. Navarro, we want to express our appreciation to the court, to Judge Mehta, and to the jury that considered this case. This is an important case. This is a landmark case. This case, while we have a decision and we respect the jury's verdict today, this case won't be decided here finally. It will be decided by the D.C. Court of Appeals. This is the first time that a senior presidential aide who has served his president for 4 years has ever been held in contempt of Congress. There are legal issues here that need to be decided by the Court of Appeals. Judge Mehta decided, based upon an evidentiary hearing last week, that there was inadequate evidence to show that President Trump had formally instructed Dr. Navarro to invoke executive privilege. Respectfully, we disagree with that decision. We think that the evidence established that in fact President Trump instructed Dr. Navarro to invoke executive privilege. But in any event, we think that based upon the separation of powers between Congress and the executive, that executive privilege is part and parcel of the office of the President of the United States, and that no express invocation of privilege was even necessary. Otherwise, President Reagan, for example, would have no executive privilege, and any confidential conversations he had with his senior aides at the time would be waived, and you all could ask his aides what President Reagan spoke to about sensitive matters. So we think it's part and parcel of the office. We're confident that the Court of Appeals will hold to that effect, and this case is not over by a long shot.
No, I don't have anything much more to add to what Mr. Raleigh just said. Yeah, today was an important step in the direction of a successful appeal. And that's about all I have to say. You seem to have missed the joke there.
All right, let me see if I can break this down for you, and you guys, you're good to go if you want. This is going to be a while. All right, so let's start with the fact that this is a landmark case. This is a landmark case that's bound for the Supreme Court. Why do I say that? This is the first time in the history of our republic that a senior White House advisor, an alter ego of the president, has ever been charged with the alleged crime. That's the first time that this has ever happened. Now, At the same time, what's so remarkable about this case is that even as the Department of Justice was bringing this case, they had a policy for more than 50 years that says people like me, senior White House advisors, alter egos of the president, cannot be compelled to testify before Congress. Absolute. Yet they brought the case. This case is a landmark case because it's about the constitutional separation of powers. That goes back to the days of George Washington, when the legislative branch first began to try and meddle with the executive branch. And if you go back and look at the Supreme Court rulings, few and far between all they are, and more importantly, the Department of Justice position, then you will understand that there are very good reasons why executive privilege is sacrosanct. It's the mechanism by which effective presidential decision making is made. So this case is not about me. I happen to be the only one in the barrel on this. And what's interesting about this case is that Judge Amit Mehta, during the course of this case, actually made history. How did he do that? He made history by ruling that people like me, senior White House advisors, cannot be compelled to testify. He said that. No judge has ever said that before. Now, the reason why he felt that it did not apply to me is because he did not believe, despite all of the evidence we put on, including my own personal testimony, that the privilege had been properly invoked. And that's another open question for the appeals court, because there are many legal scholars who believe that the privilege is presumptive. Presumptive. There are many other issues that are related to this case that are open questions. But at the end of the day, the day that Judge Mehta ruled that I could not use executive privilege as a defense in this case, the die was cast. This was pro forma. Pro forma. We knew going in what the verdict was going to be. That's why this is going to the appeals court.
Okay, we will leave that there. That's Peter Navarro speaking outside court, one of Donald Trump's key White House aides. He's just been found guilty of 2 counts of criminal contempt of Congress. He refused to appear before a committee of lawmakers last year. That committee was investigating the attacks on the US Capitol building, January 6th, of course. And prosecutors told the jurors there Navarro acted as though he was above the law when he refused to give evidence. And you heard him saying there that he will appeal against this decision.